The EMS training officer position, formerly EMS assistant, shall be filled by the process established in this article. Eligible applicants must currently be commissioned to the rank of lieutenant. The EMS training officer position shall normally be a 2-year appointment and shall normally begin in January of an even-ending year. Eligible officers who wish to apply for the position shall do so in writing to the deputy chief within an application period established by management. The selection for EMS training officer from the pool of eligible applicants will occur through a process established by the fire chief or his/her designee. Should no lieutenant from the bargaining unit apply for the position of training officer during the application period, the lieutenant with the least amount of seniority in rank will be appointed to the position for no greater than 1 calendar year. Should a vacancy occur midterm due to separation of employment by the EMS training officer, the position will be open to all bargaining unit lieutenants for application. Should no eligible lieutenant apply for the EMS training officer position, the candidate from the lieutenant eligibility roster who is promoted to fill the vacant lieutenant position shall fill the position to completion of the calendar year. Should no new promotion from the lieutenant eligibility list occur after the most recent lieutenant appointment to the position, the next most recently promoted lieutenant shall be appointed to the position of EMS training officer for a duration no greater than 1 calendar year. If a lieutenant is forced into the position, they will be relieved of any other force mechanism for either EMS training officer or training officer upon completion of the 1 calendar year. Article XXI, Board of Fire and Police Commissioners. Nothing in this agreement is intended to diminish the authority of the City Board of Fire and Police Commissioners, BFPC, with respect to the hiring of bargaining unit employees. The BFPC retains the right to adopt and enforce rules and regulations in connection with administration of the promotional process, provided such rules and regulations are in conformity with Article XX, Miscellaneous Provisions, Article XXII, Discipline, Discharge and Personnel Records, and Article XXV, Promotions. Article XXII, Discipline, Discharge and Personnel Records. Section 22.1 Third-party investigations. The parties recognize that in certain instances city employees are accountable to a third-party agency for their conduct. When a third-party agency initiates an investigation into employee conduct, the parties agree on the following process. Where a third party calls for an investigatory meeting to be held with the involved employee, the city will exercise its best efforts to ensure the meeting will take place no sooner than 24 hours after the end of the shift during which the triggering incident occurred. If an employee has any license needed to perform his job suspended by a third party, the employee shall serve an unpaid suspension from employment for the period that the license is suspended. The city shall perform its own investigation of the incident. If the fire chief determines from that investigation that the third-party suspension or the length of suspension was unwarranted in whole or in part, the city shall make the employee whole for the difference between the time served under the license suspension and the length of suspension, if any, imposed by the fire chief. The make-whole remedy shall be implemented by crediting the employee's compensatory time bank. This credit will not count toward the 108-hour compensatory time bank limit. Nothing herein shall preclude the chief from imposing a higher level of discipline than that imposed by the third party, subject to challenge through the grievance/arbitration process. Section 22.2 Discipline and Discharge. Any supervisor may issue an oral or written reprimand. Any officer of the rank of division chief or above may temporarily suspend a subordinate employee with pay and/or recommend a demotion, unpaid suspension, or dismissal. The fire chief or the acting fire chief may suspend non-probationary employees without pay for up to 45 calendar days or as may otherwise be agreed between the fire chief and the union, demote, or dismiss any such employee. The sole recourse for appealing unpaid suspensions, demotions in rank and pay grade, and dismissals shall be to file a grievance under Article 9. It is expressly agreed that the employee who is the subject of the disciplinary action shall have no right to appeal any disciplinary action to the City Board of Fire and Police Commissioners. Oral reprimands shall not be subject to the grievance procedure, or to appeal to the Board of Fire and Police Commissioners. Written reprimands may be grieved to Step 3 of the contractual grievance procedure, but not to arbitration or appealed to the Board of Fire and Police Commissioners. If the fire chief or the acting fire chief dismisses a non-probationary employee and such employee elects to appeal the decision, the grievance shall be processed in accordance with Article 9 of this agreement, except that it shall be filed at Step 3 of the procedure. Thereafter, if an arbitrator determines that the suspension or dismissal was not supported by just cause, the arbitrator shall have the authority to rescind or to modify the action in order that the employee be made whole for any lost wages incurred as a result of disciplinary action, or portion thereof, that is not sustained by the arbitrator. During an employee's probationary period, the employee may be suspended, for up to 3 duty days or less, or terminated by the city, with or without cause. No grievance shall be presented or entertained in connection with such a suspension or termination of any probationary employee. Pursuant to Article 7, Section 6, of the Illinois Constitution of 1970 and Section 15 of the IPRA, the foregoing provisions with respect to discipline and the appeal and review of discipline shall be in lieu of, and shall expressly supersede and preempt, any provisions that might otherwise be applicable under either 65 ILCS 5/10-2.1-17, or the rules and regulations of the City of Naperville Board of Fire and Police Commissioners. Section 22.3 Administrative Leave Pending Investigation. When an employee is alleged to have engaged in serious misconduct, but the city has not had sufficient opportunity to investigate the allegations to make a final disciplinary determination, the city may place the employee on administrative leave with pay pending the outcome of the investigation. Provided, however, whenever an employee has been indicted or charged with a felony, then such employee may be temporarily placed on an unpaid leave, provided such employee is afforded a reasonably prompt opportunity to be heard. Section 22.4 Right to Representation. Nothing in this agreement is intended to add to, detract from, or waive an employee's existing legal right, to have a representative present during any investigatory meeting where the employee reasonably believes he may be subject to discipline. Section 22.5 Personnel Records. An employee shall be provided with access to his or her personnel record in accordance with the Illinois Personnel Record Review Act, as amended, 820 ILCS 40/0.01. Section 22.6 Removal of disciplinary records from personnel file. Records will be expunged only at the written request of the affected employee, following the procedure set forth herein. Upon request, records of misconduct and disciplinary action shall be expunged by the fire chief, or his designee, from the employee's personnel file in the following manner. Records of investigations and incidents that do not result in discipline, immediately upon employee request. Verbal counseling/oral reprimand, after 1 year with no additional incident requiring further discipline. Written reprimand, after 3 years with no additional incident requiring further discipline. Suspension, after 5 years, unless an allegation involving excessive force, harassment, discrimination, dishonesty in the performance of fire department duties, or criminal conduct as referenced below. A finding or sustained allegation of misconduct involving excessive force, harassment, discrimination, dishonesty in the performance of official fire department duties or criminal conduct may be weighed in future disciplinary proceedings to determine credibility, notice, and the appropriate penalty. Section 22.7 Firemen's Disciplinary Act. Nothing in this agreement shall be construed to preclude the applicability of the Firemen's Disciplinary Act, 50 ILCS 745/1 ETSEQ, but said disciplinary act shall not be incorporated herein by reference. Section 22.8 Pre-termination meeting. Unless a formal interrogation has been conducted pursuant to the Firemen's Disciplinary Act, prior to discharging a non-probationary employee, the fire chief or his designee will offer to meet with the employee, describe the reason or reasons why dismissal is being contemplated, and afford the employee an opportunity to state his/her side before a final decision is made. Article XXIII, Outside Employment. Employees shall notify the chief in writing of any outside employment. Outside employment shall be defined as employed by an employer, contracting for or accepting anything of value in return for services and/or self-employed for remuneration. Employees may be allowed to work on outside employment on their days off, provided such employment shall not result in a conflict of interest, bring the city into disrepute, result in outside work during an employee's work shift, involve the use of city equipment, supplies, or facilities, or adversely impact the employee's ability to do the job for the city. The union and city agree that like work, which for purposes of this provision is defined as any active full-time, privatized, paid on-call, volunteer, or any other class of work that provides emergency fire or pre-hospital emergency operational service or ground transportation work as provided by the City of Naperville Fire Department bargaining unit members, hereinafter like work, shall be restricted under the following guidelines. Newly hired employees shall be prohibited from performing like work. Any employee who leaves, is terminated, or otherwise severs their relationship with their current, approved like work, shall be prohibited from performing any future like work. When an employee leaves, is terminated, or otherwise severs their relationship with their current, approved like work, that employee is required to submit written notification within 30 days to the fire chief of their status. Article XXIV, Department Rules. Employees shall be required to comply with all rules and regulations, policies, and procedures of the city assuming such are not inconsistent or in conflict with the terms of this agreement. In the event there is a dispute as to whether a rule, regulation, policy, or procedure is in conflict with or is inconsistent with the terms of this agreement, it is agreed that the employees will comply with the rule, regulation, policy, or procedure upon the direction of the supervisor, and any dispute over the matter will be resolved through the grievance procedure. Article XXV, Promotions. Section 25.1 General. Promotions to the ranks of captain and lieutenant shall be conducted in accordance with the provisions of the Fire Department Promotion Act, as amended 2008 to 50 ILCS 742, hereinafter the Act. A copy of this Act is attached as Appendix E to this agreement. Except where expressly modified by the terms of this article, the procedures for promotions shall be made in accordance with the provisions of this Act, with the promotional process to be conducted and supervised by the City of Naperville Board of Fire and Police Commission, hereinafter the BOFC. Section 25.2 Vacancies. This article applies to promotions to vacancies in the ranks of lieutenant and captain. A vacancy in the rank of captain or lieutenant shall be deemed to occur on the date upon which the position is vacated, provided that the position continues to be funded and authorized by the city. When a vacancy occurs in the position of captain, a vacancy shall be deemed to occur in the rank of lieutenant, provided that either or both positions continue to be funded and authorized by the city. If a vacated lieutenant or captain position is not filled due to the lack of funding or authorization and is subsequently reinstated, i.e., funded and authorized by the city, the final promotion list shall be continued in effect until all lieutenant and/or captain positions that were vacated and not filled due to the lack of funding or authorization have been filled, or for a period of 4 years beginning from the date on which the applicable position was vacated, whichever occurs first. In such event, the candidate or candidates who would have otherwise been promoted when the vacancy originally occurred shall be promoted. Section 25.3 Eligibility Requirements. The examination process for promotion to the rank of lieutenant shall be competitive among employees in the rank of firefighter or firefighter-paramedic who meet the eligibility requirements set forth in subsection A below and desire to submit themselves to such process. The examination process for promotion to the rank of captain shall be competitive among employees in the rank of lieutenant who meet the eligibility requirements set forth in subsection B or C, beginning in 2015, below and desire to submit themselves to such process. Lieutenant. Members of the bargaining unit shall be eligible to participate in the process for promotion to lieutenant if they have served a minimum of 5 years on the Naperville Fire Department, including probation, as of February 1st of the year in which the exam is administered, and are certified as Fire Officer I, or Company Fire Officer as defined by the Illinois Office of the State Fire Marshal or equivalent as mutually agreed upon by Labor and Management, by February 1st of the year in which the exam is administered. For the lieutenant's testing process, the date for these requirements is as of no later than 5 p.m. at the close of application. Captain. Members of the bargaining unit in the rank of lieutenant shall be eligible to participate in the process for promotion to captain if they have served a minimum of 3 years in the rank of lieutenant in the Naperville Fire Department as of February 1st of the year in which the exam is administered, and are certified as Fire Officer II or Provisional Fire Officer II or Advanced Fire Officer or Provisional Advanced Fire Officer as defined by the Illinois Office of the State Fire Marshal, or equivalent as mutually agreed upon by Labor and Management, as of February 1st of the year in which the exam is administered, and have a minimum of an associate's degree or official transcripts stating all requirements for degree completion have been met by February 1st of the year in which the exam is administered. For the captain's testing process, the date for these requirements is no later than 5 p.m. at the close of application. Section 25.4 Components of the promotional process and the weighting of components. The placement of eligible candidates on a promotion list shall be based on the points achieved by the candidate on each of the following 5 components weighted as specified. Order of administration. Component. Percentage. Weighting. Lieutenant. Percentage. Weighting captain. 1. Seniority. 20%. 20%. 2. Ascertained merit. 10%. 10%. 3. Assessment center. 35%. 35%. 4. Written examination. 35%. 35%. If a candidate wishes to withdraw from the promotional process before the completion of all the components of the promotional process, the candidate shall so advise the fire chief in writing. Section 25.5 Promotion Process Components. The components of the promotional process shall be as follows and shall be administered in the order set forth above. Seniority. As of February 1st of the year in which the test is administered, seniority shall be calculated as follows. The most senior candidate up to a maximum of 25 years of service shall be awarded 100% of the points available for seniority component. Less senior candidates shall be awarded points pro rata based upon the most senior candidate's years of seniority. For example, 26 years equals 100%. So, 12 years 6 months equals 150 months divided by 300 months equals 50%. The total point value shall not exceed 100 points. Article XXVI, Drug and Alcohol Testing. Section 26.1 Policy Statement. The term illegal drugs herein is defined as any drug that is unlawful under either federal or state law, except for cannabis. The use of illegal drugs, abuse of legal drugs, and/or abuse of alcohol by members of the Naperville Fire Department present unacceptable risks to the safety and welfare of employees and the public. It is the policy of the City of Naperville, and the Union agrees, that the public has the right to expect persons employed by the city to be free from the effects of drugs and alcohol while on duty. Section 26.2 Voluntary Requests for Assistance. The city shall take no adverse employment action against an employee for voluntarily seeking treatment, counseling, or other support for an alcohol or drug-related problem, provided such request is made before an employee is directed to submit to a drug and/or alcohol test under this agreement or has been charged or cited for an alcohol or drug-related incident. The city may reassign an employee seeking voluntary treatment with pay if while receiving voluntary treatment he is determined to be unfit for duty in his current assignment. The city shall make available through its Employee Assistance Program a means by which the employee may obtain referrals and treatment. All such requests shall be confidential and any information received by the city, through whatever means, shall not be used in any manner adverse to the employee's interests, except reassignment as described above. If an employee voluntarily requests such assistance with an alcohol or drug-related problem, as described above, the employee will be permitted to return to regular work duties only after successful completion of a return-to-work medical examination, including testing negative for alcohol and drugs. The employee shall also be subject to random testing for drugs and alcohol for 12 months following their successful return to work. Employees may request assistance pursuant to this section without incurring an adverse employment action not more than once within any 3-year period, nor more than twice within any 10-year period. Section 26.3 Prohibitions. Employees are prohibited from consuming or possessing alcohol or cannabis at any time during the workday, anywhere on any city premises or job site, while engaged in city business. Possessing, selling, purchasing, delivering, or consuming any illegal drug or selling cannabis at any time. Being under the influence of alcohol, cannabis, or any illegal drug during the course of the workday. Failing to report to their supervisor any known side effects of over-the-counter medication or prescription drugs, which they are taking which may adversely affect their job performance, or the use, while on duty, of any drug which is legal, in the absence of a required medical prescription, in excess of a prescribed dosage, or in a manner inconsistent with physician approval, to the extent that such usage causes impairment. Section 26.4 Drug and Alcohol Test Criteria. When the city has reasonable suspicion to believe that an employee is under the influence of alcohol, cannabis, or illegal drugs or is impaired by legal drug use, or any combination thereof, the city shall have the right to require the employee to submit to alcohol or drug testing as set forth in this agreement. The determination to test shall be made by a supervisor, in consultation with a chief officer, based on any or all of the following. Specific observations of use or possession. Physical symptoms of being under the influence or the withdrawal effects of illegal drugs, cannabis, or alcohol. Patterns of abnormal or erratic behavior concerning an employee's appearance, conduct, speech, behavior, or body odors. Being found guilty of a drug-related offense on or off duty. An employee may also be required to submit to alcohol and/or drug testing for a. any on-duty vehicular accident which a driver/apparatus operator causes which significantly damages equipment or property, or which results in a personal injury requiring emergency medical treatment away from the scene of the accident, or b. any personal injuries which an on-duty employee causes to another person which requires emergency medical treatment away from the scene of the incident. Section 26.5 Order to submit to testing. Where an employee is ordered to submit for testing, the employee shall be permitted to contact a representative of the union at the time of the order. However, the testing process shall not be delayed to provide the assistance of a union representative who is not immediately available. No employee shall be interrogated by the city without being accorded their rights under the Fireman's Disciplinary Act, 50 ILCS 745/1 ETSEQ. No employee shall refuse to submit to alcohol or drug testing, refuse to consent to the release of drug or alcohol test information to the city, or otherwise refuse to cooperate in the administration of drug or alcohol testing in accordance with this agreement. An employee's submission to drug or alcohol testing under this section shall not be construed as a waiver of any objection or rights the employee may have. Section 26.6 Tests to be conducted. In conducting testing under this agreement, the city shall ensure the following. Any employee ordered to submit to drug testing will not be allowed to drive, and will be accompanied to the collection site by a supervisor. The employee will not be allowed to return to work until the test results are known. The city reserves the right to test for alcohol if an employee tests positive for any illegal drug or prescription drug in excess of the prescribed dosage. Laboratories used for drug testing shall be certified in accordance with SAMHSA standards. All procedures at a blood or urine collection site will be conducted in accordance with adopted standards and procedures pursuant to 49 CFR Part 40 as amended from time to time. No urine collection shall be witnessed unless there is reasonable suspicion that the employee has or may attempt to tamper with the sample. A sufficient sample of urine or blood will be collected to allow for initial screening, a confirmatory test, and an adequate reserve for later testing if requested by the employee. Provide the employee tested with an opportunity to have the additional sample tested within 48 hours of the ordered test by a clinical laboratory or hospital facility of the employee's own choosing, at the employee's own expense, provided the employee notifies the Human Resources Director within 48 hours of receiving the results of the employee's independent tests. Urine testing will consist of an initial screening with an enzyme multiple immunoassay test, EMIT, and confirmatory testing shall be conducted with gas chromatography/mass spectrometry, GC/MS, or an equivalent or better scientifically accurate and accepted method that provides quantitative data about the detected drug or drug metabolite. Require that the laboratory or hospital facility report to the city that a blood or urine sample is positive only if both the initial screening and confirmation test are positive for a particular drug. The parties agree that should any information concerning such testing or the results thereof be obtained by the city inconsistent with the understandings expressed herein, e.g. billings for testing that reveal the nature or number of tests administered, the city will not use such information in any manner or form adverse to the employee's interests. Provide each employee tested with a copy of all written information and reports received by the city in connection with the testing and results. Ensure that no employee is the subject of any adverse employment action except emergency temporary reassignment or relief from duty with pay during the pendency of any testing procedure. Any such emergency reassignment or relief from duty shall be immediately discontinued in the event of a negative test result. For purposes of this agreement, under the influence of alcohol shall mean a blood alcohol level equal or exceeding 0.02 grams of alcohol per 100 milliliters of blood as determined by evidential breath testing, EBT. A drug test will be deemed positive if it indicates the presence of any illegal drug, cannabis, or any drug levels in excess of SAMHSA, Substance Abuse Mental Health Safety Administration. A positive cannabis test can be used to make a determination of on-duty impairment only if the employee exhibits other symptoms of impairment which are observed by a supervisory employee prior to being sent for testing. Section 26.7 Right to contest. Nothing herein shall be construed as a waiver of the employee or the union's right to file a grievance over alleged violations of this article. Where disciplinary action is imposed against an employee for violation of this article, the employee will be entitled to an opportunity to explain or challenge the drug or alcohol test results during a meeting held in accordance with the grievance procedure of this agreement, to the extent the employee files a grievance pertaining to such discipline. Such grievances shall commence at Step 2 of the procedure. Section 26.8 Discipline. An employee shall be subject to discipline up to and including discharge where the employee violates any of the prohibitions of Section 26.3. Provided, however, that in the first instance an employee tests positive for being under influence of alcohol, cannabis, or for abuse of prescription drugs while on duty, absent aggravating circumstances or other rule violations, the employee will be subject to discipline, but not dismissal, if the employee requests and completes treatment through the city's Employee Assistance Program, EAP, and enters into a last chance agreement in a form approved by the city attorney. Agrees to appropriate treatment as determined by the city physician. Completes the course of treatment prescribed, including an aftercare group for a period of up to 12 months. Agrees to submit to random testing for alcohol and/or drugs during the rehabilitation period and for up to 12-month period after the employee's return to work. Employees who do not agree to or who do not act in accordance with the foregoing, or test positive a second or subsequent time for the abuse of alcohol or abuse of prescription drugs while on duty, or who again violate any of the prohibitions in Section 26.3, shall be subject to discipline, including discharge. Nothing in this agreement shall be construed as an obligation on the part of the city to retain an employee on active status throughout the period of rehabilitation if it is appropriately determined that the employee's current use of alcohol or drugs prevents such individual from performing their duties or that such active status constitutes a direct threat to the health or safety of others. Such employees shall be afforded the opportunity to use all accrued sick leave, vacation while attending a treatment program, and will be granted FMLA leave, to the extent applicable, or an unpaid leave of absence to complete such program after exhausting such accrued paid time off. The city's obligation to pay for treatment for alcohol/substance abuse will be limited to services provided by the city's medical insurance plan. Article XXVII, Savings Clause. In the event any article, section, or portion of this agreement should be held invalid and unenforceable by any board, except a city board, agency, except a city agency, or court of competent jurisdiction or by reason of any subsequently enacted state or federal legislation, such decision or legislation shall apply only to the specific article, section or portion thereof specifically specified in the board, agency, or court decision or subsequent litigation, and the remaining parts or portions of this agreement shall remain in full force and effect. In such event, upon the prompt request of either party, the parties shall meet promptly and negotiate with respect to substitute provisions for those provisions rendered or declared invalid and unenforceable. Article XXVII, Entire Agreement. This agreement, upon ratification, supersedes all prior practices and agreements, whether written or oral, unless expressly stated to the contrary herein, and constitutes the complete and entire agreement between the parties, and concludes collective bargaining for its term unless otherwise expressly provided herein. The city and the union, for the duration of this agreement, each voluntarily and unqualifiedly waives the right, and each agrees that the other shall not be obligated, to bargain collectively with respect to any subject or matter referred to or covered in this agreement, including the impact of the city's exercise of its rights as set forth herein on wages, hours, or terms and conditions of employment. This paragraph does not waive the right to bargain over any subject or matter not referred to or covered in this agreement which is a mandatory subject of bargaining and concerning which the city is considering changing during the term of this agreement, provided the union makes a timely and proper request to bargain over the change being considered by the city.